My presentation is on ADR, or Alternative Dispute Resolution. I'm going to give a basic overview of what it entails and how it differs from the court system, what are some of the benefits, and then also what levels of control the parties have that decide to use ADR. So a basic definition of ADR is any method of resolving disputes other than litigation. So litigation usually takes place in the courtroom and has binding decisions that the parties have to abide by, and ADR seeks to provide a different solution to that. So, although in some cases in ADR the decisions can be reviewed by a court, some of the benefits of ADR is that they're independent, or it is independent from the court system, like I said. It allows the parties that participate in ADR to maintain control over the proceedings, and generally there's lower monetary costs to ADR than to going through the court system. So overall, it's a little more economical, and they have a little bit more control over what they got going on. So the ADR Continuum, there's seven levels of ADR. They go from negotiation to facilitation, mediation, expert appraisal, conciliation, then there's the expert determination, and then finally is arbitration. So, and starting at negotiation, that's the lowest level, and it goes up from there. So the level of control that the parties have decreases as the level increases. And then also, if there's any type of decision-making process, the level of control for the parties with decision-making also decreases as well. So I'll give you a brief overview of each one, kind of just to give you an idea of what each one kind of entails and what it looks like. So, and I'm looking at the Washington State Bar Association website to kind of get a good overview there. So, and I provided a link to that in the references section of that. So starting with negotiation, it's the lowest level, so there's the most control between parties. There's usually not a mediator or a third party that's trying to mediate between the two groups. Usually both parties can talk directly to each other and try to come to an agreement on whatever issue they're disagreeing on. So that's preferable, like with anything. If you could resolve something at the lowest level, that's definitely preferable to, having to use a third party. So mediation, that's where you actually have a mediator, and that's an impartial third party that takes part in the proceedings and kind of just helps facilitate the discussion, helps kind of frame the issues, provide a framework for what the problems are, what they're trying to resolve, and what some of their goals might be. So that's another thing with mediation, is it's not necessarily an us versus them mentality, but it's more trying to see what are the common goals they have, or let's focus on the positive goals and how can we both compromise to reach those. So that's the basics of mediation there. Let's look at the next one. Oh, I forgot facilitation. So a facilitator is before mediation. It's a little bit lower than mediation. It's also along the same lines as that, but basically they're facilitating discussion and not doing much more than that. And I don't have a lot of information on that one. So again, mediation. The mediator doesn't have any type of authority to impose a settlement. They basically just try to define the issues, like I said, and go from there. Look at the next one, see what we got here. I want to make sure I get all the information right here. There's an expert appraisal, and underneath that, expert appraisal has a couple different subsets. They have like an early neutral evaluation and also something called fact-finding. So our fact-finding comes before the early neutral evaluation. And fact-finding is basically what it sounds like. They hire a third-party individual again. That individual takes the time out to objectively look at all the facts surrounding the case, see if they could frame the issues kind of like a mediator, and present those facts to the parties. So they're not making a decision or anything like that. They're just trying to get all the information, might interview people that are involved with the case, and go from there. And then you have the early neutral evaluation. So the E&E, it's chosen by the parties. That's the thing with all these things is if it's not involved in the court system, which is normally not, the mediator or the arbitrator that we'll talk about later, or the early neutral evaluator, those are usually all decided upon by both parties. So not just one side or the other, but because it's a collaborative process, they both decide on who they want to do these things. So what they do with that is, I'm trying to think exactly, early neutral evaluation. It's part of expert appraisal, and so it kind of narrows the issues down a little bit more, where a mediator kind of tries to frame the issues. Expert appraisal, it narrows it down even further and tries to really get to the crux of the issue. That takes out a lot of the need to kind of, get distracted by talking about too many issues. They want to try and narrow it down to what's the important stuff. What do we really need to talk about? Let's see what else there is. There's conciliation. Let me see, conciliation. Let me see what information I have on that. I tried to do my research for this before I decided to videotape, but things always turn out a little bit differently once you get in front of there. So, conciliation. I'm trying to think. Let me take a look in my notes real quick, if I can find out. This is different for me to do it by video, and I really hope that I'm able to do the file properly and not mess it up. So we'll see what we do. So conciliation, let's see, I blame Dr. Jarrett for this because he didn't, now it's my fault for not having that information on conciliation. I'll take a look at my notes again, just to make sure. Conciliation, well, it says that it brings together, my notes said, bring together for the benefit of the mediator. So, you have an early neutral evaluator. I think that they work with the mediator for conciliation, which, like I said, is they brings all the facts together for the benefit of the mediator. And you get all the facts, and then the mediator is able to weigh the facts that the E&E has gathered, and that helps them with kind of trying to reframe the issue with the parties again. So, expert determination. That's kind of what exactly what it sounds like. That's one step below arbitration. So at that point, the control that the parties have over the process is starting to diminish a lot. So expert determination, I don't think they make binding decisions, but they kind of give, what it sounds like, an expert determination on the issue, and then it's up to the parties to see whether or not they want to follow that. So, and then lastly is arbitration. So, arbitration can be either binding or non-binding, and again, both parties have to decide on that. So, generally, that's just below litigation, which is of course in the court system. So, arbitration on the continuum of how much control the parties have, arbitration is pretty high up there as far as the lack of control. So, and usually at that time, if they do agree on, excuse me, if they agree upon a binding decision, then the arbitrator can impose a decision. So, with like negotiation and mediation, those two, the the mediator can recommend. They can recommend things, but they don't actually get to impose a decision. It's basically, if it comes to that, like you get an E&E appraisal, and you get to conciliation, get the information to the mediator. From there, then they can give their recommendation, but they can't actually impose a decision like they can in arbitration. So, and outside of the court system, arbitration is voluntary, so it's voluntary between the two parties. And then again, the issues can be binding or non-binding. So I have an example of a non-binding arbitration, and it's been in the news just recently, and that's what I'll talk about here in a second. So ironically, one thing, this is a side note, but when it comes to arbitration, they have like court-ordered arbitration or mediation, and that's where arbitration is mandatory. It can be mandatory. If arbitration is mandatory, generally the decision is non-binding though. So they may mandate two parties to enter into arbitration as opposed to a different form of dispute resolution. But if the court mandates them to do that, they can't actually mandate them to follow the decision, because basically that's litigation. So that kind of raises a question of what's the purpose of arbitration if you're mandated to go to it? You know, it's a little bit different. Something to think about. So let's talk about example of ADR. So the Fairbanks Teachers Union, this is this year, just within the last month, and the Fairbanks North Star Borough School District. Recently they reached an impasse on, they had two negotiation sessions where it was just the two parties talking to each other, trying to come to a resolution, and the topic or the point of contention was concerning pay raises and cost of living expenses, I believe, or a stipend. There was $1,500 a month stipend, I think, in addition to raises. Let me look the article up real quick. I have it listed in the in the references page, but if I could take a look at it, it would be helpful also, just to make sure. Yeah, so the district, it proposed a 1.25% salary increase and a $1,500 stipend for teachers who aren't eligible to make that movement up on the salary schedule. So where the dispute came was because they disagreed on how long the people would get the $1,500 stipend. The district said that they would offer that to teachers for 1 year, but the teachers union wanted it to continue beyond a year, and so that was like the point of contention between the two parties, where they couldn't come to a resolution. So they called in a arbitrator from Seattle. Let's see, it doesn't give his name on it. Oh, yep, Richard Humphreys. He's an arbitrator from Seattle, and he came up to meet with the group. He went over all the information, took into consideration cost of living, like I talked about earlier. He took into consideration the finances of both parties, and also what the issues were, if it was reasonable or not. And he ruled in favor of the Fairbanks North Star Borough, the school district. So that was his ruling. Now it's non-binding. He didn't give a binding decision. He basically kind of just gave his advice on what was fair and what was equitable in this situation. So the parties are not at all obligated to follow that, but it kind of gives them an idea of how to frame the issues if they go back into contract negotiations. So that's an example of non-binding arbitration. Sometimes it's kind of dry, but that's a little bit interesting once you get a good foundation of it. So, and again, that was after they tried negotiation, so they started at the lowest level in the ADR continuum. I'm not sure if they tried a mediator. It seems like the gentleman, the arbitrator from Seattle, acted kind of in the place of a mediator, but they asked him to review the information and give, what do they call it there? Like his expert determination, basically. So it was right below right below litigation and a binding decision with arbitration. And that has the least level of control with the parties. So what's good about ADR? I gave a real basic overview of it. It can be used effectively to resolve disputes outside of the court system. And I know that's why it's real big, or starting to come up real big these days. The court system has a lot of court cases, a lot of money that's spread out in different areas, and a lot of the resources that the courts have are just being spread too thin. So if ADR can be used to address some of those issues instead of going to the court system, it's usually faster, and it gives more control to the different parties. So, and then of course it depends on the level of ADR, but generally that's a big thing. When it comes to court and litigation, you're having a judge give the decision. Basically, you don't have any control over that. You can present the case and present your information, but as far as a resolution to it, you don't have any control over that. So with ADR, you have some control over the process, starting with negotiation, just the two parties talking, moving into mediation. You even they have control. They could pick the mediator, make sure it's a neutral individual, decide who pays for what, who pays for whose services, maybe split the cost of the mediator. And then into arbitration also. A little bit less control, but also still, non-binding decisions a lot of the time. Unless they agree, both parties have to agree to a binding decision. So there's still even that bit of control. So, and it's a positive alternative to the court system for the reasons I listed before. So, real basic overview. I'm going to end the presentation and see if I can upload this. I'm going to try and upload it. Let me take a look and see what I used here. Vicasmo seemed to look like to be the one that I wanted to use. They gave me more time and was able to kind of work with what I needed. So hopefully it'll work. I don't know. I'm going to upload it and see. So thank you.